Good afternoon and welcome to CUHK Law and the latest in our Greater China Legal History Seminar Series. My name's Stephen Gallagher and it's my great pleasure to introduce our speaker today. But before I do so, can I just say that our speaker is going to try and leave some time at the end for some questions. So I'm sure you will have questions about this fascinating topic today. So please remember to use the chat function and chat the questions into us, and then we can raise those questions with Professor McManus at the end. So let me introduce our speaker. Our speaker is another of our friends from the history department at CUHK, and he's already been a speaker with the seminar series before. So Stuart McManus is Assistant Professor of History at the Chinese University of Hong Kong. He received his PhD in History and Classical Philology from Harvard University. At Harvard, he also studied civil law with Charles Donoghue Jr., which led to a co-authored study of barbarian family law. Subsequently, during a 2-year fellowship at the Stavanovich Institute on the Formation of Knowledge at the University of Chicago, he co-taught a course with Clifford Ando of the University of Chicago Law School. He's written widely on various topics in Western and world history, and his study of the global impact of the Roman courtroom orator Marcus Tullius Cicero appeared with Cambridge University Press in 2021. He also, it's not in his bio, but he also did speak at the Greater China Legal History Seminar Series before, back in January of 2020, on law and slavery in the South China Sea. And we were very, very keen to get Stuart back. So when he suggested this topic to us, we thought this would be a great topic to start the Lunar New Year with. So Stuart will be talking today on early cross-border legal issues, law in the age of Matteo Ricci. Over to you, Stuart.
Great, thank you so much, Steve, for the very kind introduction. And it's really great to be back at the Greater China Legal History Seminar. It was a real pleasure to present the first time, and it's even a greater pleasure to be asked back, I suppose. Let's make a start, shall we? I want to start with something that most of us haven't done for a while, and that is travel, albeit virtual travel. I want to take you to one of my favorite research locations. This is the Jesuit quarter of the Eternal City of Rome. It's an area of the city that's positively brimming with libraries and churches and colleges and all the sorts of things that get historians very, very excited. And I first want to take you to the great Jesuit church of Sant'Ignazio, with its wonderful Baroque facade and its even more striking Baroque interior, with its towering Corinthian columns and its beautiful dome and altarpiece, and its even more magnificent ceiling with its trompe d'oeil effect showing the Ascension and the 4 continents into which the Jesuit missionaries had spread Christianity, Asia, Africa, Europe, and the Americas, each represented by its archetypal animal. This is zooming into Asia. You see for 17th century Europeans, the camel was the sort of mascot of Asia. Let's head out of Sant'Ignazio and go down another street, shall we? Let's make our way towards another beautiful Jesuit church, roughly from the same period. It's a little bit later. This is the Gesù, which is constructed right beside the Jesuit college, the main Jesuit place of learning globally. And there I want to take you down a little corridor, where you'll encounter another piece of Baroque art, one that you might recognize. This is the painting of Matteo Ricci, probably the most famous, painted by a Chinese Jesuit lay brother who took the Christian name Emmanuel Pereira, and used, as you can see, a combination of Western and Chinese portraiture techniques, combining the realism and light perspective of the Western tradition with the style of the scholar painting, which was typical of late Ming China. And then at the bottom, we have that wonderful Latin inscription, which tells us clearly who the sitter is. Pater Matteus Riccius, Maceratensis, qui primus ex societate Jesu evangelium in sinas invexit, obit anno salutis, millesimo sexagentesimo decimo, aetatis sexaginta. So the sitter, as it says, is Matteo Ricci of Macerata, who was the first Jesuit missionary to bring the gospel to China. He died in the year of our Lord 1610 at the age of 60. Now, most of you have heard of Ricci, of course. Born in southern Italy, then under the Spanish crown, educated in the very college where his painting now hangs, where he studied mathematics and Western humanities before heading off to Macau in 1582, where he began his famous studies of Chinese language and culture, which he was the first Westerner to master. He didn't stay in Macau, of course. He then headed into mainland China, spending a few years in Guangdong, up to the great city of Nanjing, and finally arriving in Beijing in 1598, all the time composing very influential works in Chinese, including the first Chinese world map, books of piety, the first translation of the Greek, the Greek mathematician Euclid, and a very famous book on friendship as well, which is actually quite worth reading. But there's one bit of the Ricci story that I think is often overlooked, and that is the fact that all his cross-cultural work, his translations, his friendships with Chinese literati, and his eventual arrival in the Forbidden City wouldn't have been possible without the international trade networks that centered on Macau. Macau, as you probably know, became a Portuguese trading enclave in the 1550s and was a very important stop-off in a sort of larger Eurasian trade system that the Portuguese captured in the 16th century, that went from Lisbon in Portugal to Goa in India, to China, and then to Nagasaki, a city which the Portuguese essentially founded. This final part of the trade route is actually particularly important. This is where Japanese silver mined in the great silver mines of Iwami were exchanged mostly for Chinese silks. This was a very, very lucrative trade, and one in which the Chinese during the late Ming period were actually forbidden to participate. Seeing an opportunity, of course, here, the Portuguese jumped in and became the middlemen between Japan and Portugal. With the trade in 1588 involving some 150,000 kilos of silk annually. There was also trade, of course, in other commodities. China produced, of course, the world's finest porcelain, satin, musk, mercury, which was important for silver mining, cinnabar, sugar, which is it's often overlooked, grown in southern China, and other things as well, like Chinese ink that was greatly prized, and even mosquito nets, which was an export. And now, as most of you in the audience are probably practicing lawyers, you're sort of licking your lips and thinking, wow, with all this trade, there must have been a lot of work for lawyers. There must have been a lot of legal sort of issues that touched on questions of law that arose, and indeed there were. This is something that historians haven't really appreciated to date, I think, especially when looking at the pre-Canton system period. So before, the system of the Hongs and all those things that those of you who know about the history of Hong Kong will be familiar with. There is some work, especially in Portuguese, on legal history, but this tends to ignore trade, whereas the work on trade tends to ignore law. And so I think there's a bit of a gap here, especially when it comes to non-constitutional law, which has been studied by Manuel España and others. So this is what I want to talk to you about today, and this is one of the topics I'm working on at the moment. I'm hoping to write an article on this I think neglected but very interesting topic. So today I'm going to give you an outline of some of my thinking. I'm going to start with a constitutional background to trade and the sources of law, which are multiple and complex and overlapping. I'll then deal with commercial law, broadly understood, family law, in particular issues of cross-border or cross-confessional marriage, and then I'll deal with the very interesting topic of cross-border crime, of which there was quite a bit. I'll just say a couple of words about documents first. When people write the history of Macau, they often rely quite heavily on Portuguese chronicles and official correspondence, which are really, fantastically rich sources. But they're not particularly useful for understanding cross-border law. And so what I'm going to be relying on today are the details about legal theory and practice that we find in personal manuscripts in Latin and Portuguese, as well as official Chinese documents as well, which are relatively underused, I think, in this context. So first to the constitutional background and sources of law. This, I suppose, can be rephrased as, what sort of border are we dealing with? That you see at the bottom is the border as it was. Macau was a lot smaller before the land reclamation, but there still actually is a border there. That's the northern Portas do Cerco border checkpoint in Macau, and it's the original one, which led along the thin part of the peninsula that connects Macau to the mainland. So as you probably already have a sense, it's in the mid-16th century that this soft border emerges. Macau becomes a Portuguese enclave, more or less officially ceded to the Portuguese, with the line between rent and bribes being rather thin. Money is exchanged, but quite what is happening is not always clear. The aim from the perspective of the Chinese authorities is quite clear. The aim was to limit the movement of the Portuguese, to keep them in one place where they could control them, and if necessary, cut off their food supply, which they could very easily, as there was one gate in and one gate out, and they could easily blockade the peninsula. As you'll have guessed, we are basically dealing with a situation where Chinese imperial law applies in Macau, and this is something that the Portuguese themselves recognized. There's a Portuguese jurist writing in around 1610 who makes this very, very clear. He calls Macau a colonia. This is not colony in the post-18th century English sense. This is in the Roman sense, in the sense of a settlement, initially of retired soldiers, of veterans, but a settlement of merchants, in this particular case, who occupy, in a loose sense, a particular piece of land. So our jurist, Sebastião de Amaya, a Portuguese Jesuit, tells us quite clearly, therefore, since the Portuguese residing in Macau are subjects of the Chinese emperor, so that's interesting, they are in all cases bound by his laws. Okay, so this is juridically part of China, and even the Portuguese residing there have become de facto subjects of the Chinese emperor. But this isn't quite the whole story. although it's the overarching framework. We're dealing instead with a classic case of legal pluralism, a really wonderful example of it, I think, with multiple and overlapping claims to jurisdiction and multiple and diverse sources of law. So on the Chinese side, for instance, we have all the things you would recognize from pre-modern Chinese legal history. You have the Chinese imperial codes and the subsidiary legislation. You have Chinese provincial edicts coming out of Guangzhou. You have what I suppose today we would call guiding cases and procedure, sort of a type of kind of soft law. And then, of course, you have Chinese customary law and household and lineage customs, which historians have begun to appreciate the importance of in the last sort of 10, 20 years, especially. The way that that sort of customs were sort of understood as being somewhat unique to individual households as well, not sort of to villages or town communities necessarily. So those are the laws, those are things of Chinese origin. On the European side, we similarly have Portuguese royal law, of which there was quite a lot, written in Portuguese, promulgated, sent along to Macau. You also have Macanese municipal statutes and edicts of various sorts, which sometimes bolstered, sometimes undermined Portuguese royal law. Then, of course, you have the whole European legal tradition that is normally called the jus commune. So this is civil and canon law mixed together, the kind of hodgepodge patchwork that emerges in Europe from the sort of the late Middle Ages onwards. And then, in addition, of course, we have new understandings of what we might call proto-international law that are developing in Europe and elsewhere in the 16th century. These are characterized especially by what are called natural law theories. Most of these are ultimately derived from the philosophy of Aristotle, transmitted and Christianized by Thomas Aquinas, and then scholastic philosophers in the 16th century. So this is the complex situation we are dealing with. In terms of the actual sort of exercise of Ming jurisdiction in Macau, as I said, the point of Macau is to keep the Portuguese cooped up so they couldn't, get into trouble. All the Chinese authorities were very suspicious of them, but in general, they tried to take a relatively hands-off approach, intervening only when there was a problem. And we have examples, I think good evidence for this from the Ming Shus, so the official history of the Ming, which describes instances where the authorities were called on to intervene in Macau and chose not to. We should also remember that to some extent, the Portuguese ruling elite in Macau were integrated into the Chinese bureaucracy. So, for instance, the sort of chief executive type figure, the procurador, was given a minor bureaucratic role, a minor sort of official title by the viceroy in Guangzhou, and was often called alongside the bishop to the capital city of the province to explain some particular issue or to answer questions. They were then embedded within a larger bureaucratic structure with a higher level official centered in Changshan, nowadays Zhongshan. And there was also a Chinese yamen, so a kind of courthouse official residence sort of thing, placed close to the gate. So we see this sort of mixing of the two legal and administrative systems. We also have instances where Ming officials actively legislated for Macau in particular. So, for instance, in 1617, the Ming Maritime Trade Commission promulgated a set of 5 laws for Macau that were engraved on a sort of large stone, a stele, and placed outside the Senate House. And these addressed particular issues that had arisen in the preceding decade. It said there were to be no Japanese slaves in Macau because the Chinese associated the Japanese with piracy, and they thought the presence of any Japanese, even those serving the Portuguese, was to be avoided. It also said that the Portuguese shouldn't purchase Chinese children. It also said that foreign ships, Portuguese in the first instance, but other foreign ships too, could only dock at Macau. Macau was the only way in or out. And once they'd arrived in Macau, they could only trade at Canton. So there was one way in, one way out. There was not a kind of free trade with any port kind of arrangement. Although in practice there was trade with Ningbo and other places. And finally, number 5, no new houses were to be built in Macau. The Portuguese could settle there, but they couldn't really dig themselves in too deep. They were fine. They were fine just the way they were, and this was enforced. So in 1621, a Chinese imperial judge is sent to Macau, and he removes some of the fortifications and other buildings that had been built on the Ilha Verde, on the Green Island. So they meant what they said. On the Portuguese side, on the other hand, we have a sort of slightly more sort of limited picture, in particular because the Portuguese law and sort of European customs applied mostly to the Portuguese and the Christian Chinese population. This took the form of, as I mentioned before, legislation from the king and also the viceroy at Goa in India, which was the viceregal capital of Portuguese Asia. But important things also happened in Macau. Because it was a trading center, dispute resolution was, of course, incredibly important right from the beginning. And the first official given a title in Macau was involved in this sort of thing. So very early on, there's a Capitão Mor, so a sort of great, literally great captain or sort of chief captain who's appointed in Macau. He's actually the captain of the ship sailing, the galleon sailing back and forth to Nagasaki, and he's meant to oversee. He's meant to act as a sort of mediator, arbiter sort of person. In the 1580s, there's then development. A Senate is created, the Senado, as well as an executive, the Procurador, with a series of local judges as well. This ends up getting a little bit out of hand, and so the Crown, Lisbon, then sends what we might translate as a Chief Justice to represent the interests of the Crown, although the local mercantile elite managed to sideline him fairly effectively. We should also remember that because we're dealing with a sort of Christianized legal system, therefore priests and missionaries have an important role to play. Jesuit missionaries, we know, were involved in dispute resolution, in particular in their capacity as confessors. So a Jesuit missionary would have a close relationship with a wealthy merchant. He would hear his confessions, and he would give his advice about any disputes he might have with other merchants. And here he would refer to Roman contract law. He would refer to theology, he would refer to moral philosophy, and in particular, he could also refer to these guidelines, guidelines for confessors, which gave specific advice, not necessarily for sins as we would understand them purely, but in cases of disputes or uncertainty that arose from trade as well. So this is a very sort of interesting element, I think, of the Portuguese side of the story. And of course, these Jesuits and priests are embedded within a larger ecclesiastical church hierarchy, which existed alongside the civil hierarchy in Macau, with the top of it being the Bishop of Macau, who, as I said, was often seen as kind of a joint consul with the procurador by Chinese authorities. So in short, this is our complex, pluralistic, but not necessarily disorderly situation that arose in Macau from about the 1580s onwards. So let's move on to the question of cross-border commerce and law. So let's just sort of orientate ourselves here. We know about the commodities, but how did trade actually work? Officially, trade between Macau and Nagasaki was a Portuguese royal monopoly with contracts issued, much like the Asiento system in the Atlantic. And merchants involved in this went twice per year up to Canton, generally around Christmas, and then in the kind of early summer, placing orders for silk in the summer, and then picking them up the next year. In all this, they were helped by Chinese brokers in Portuguese ceviche, which is a sort of kind of a mix-up with a similar sounding Chinese word. These brokers liaised with manufacturers and also sometimes offered credit, sometimes significant amounts of credit, which the Portuguese used to buy the silk. So they're very, very important in this whole process. This is, of course, the official trade, but there's also, of course, smuggling. The Pearl River Delta has lots of small islands. Exchanges could happen kind of behind a rock on an island, and no one would be any the wiser. This trade is also happening within the context of significant geopolitical change as well, that's worth mentioning. So this direct trade between Macau and Japan actually ends in 1637. The Portuguese are basically thrown out because we're trying to spread Christianity, and the new Edo regime in Japan was not very happy with that. They actually tried to send some ambassadors over, but believing one account says that the law of nations, so the jus gentium, proto-international law, would give them safe conduct, but the Japanese just execute them. They have no interest in continuing that trade. So that part of the trade route is cut off. However, the India, Lisbon, Goa, India, Macau trade continues. So that's that's the kind of element of change over time that we see in the age of Matteo Ricci. Digging a little more deeply into this sort of context of trade, smuggling, war capitalism, as it's called by some historians. Sometimes you get a good deal by negotiating it. Sometimes you apply a little bit of force, and you get a good deal that way. That's the way business was done in the pre-modern period. This is a world where there are competing incentives and also cultural misunderstandings. And I've given you a sort of a tripartite way of trying to understand this from the Chinese perspective. So in terms of the central government, they were, as I said, very suspicious of trade with the Portuguese, although they also recognized that they needed it, in particular for incense. The Portuguese provided the incense that was needed at court, a really important part of imperial ritual. The local government, on the other hand, had a much more positive attitude to trade because a significant part of its revenue came from the duties imposed on trade with foreigners. And arguably the local people liked it even more because they made a lot of money. They could charge the Portuguese really any prices they wanted for food because access at a day-to-day level only came through that one gate. So they kind of they had a nice little earner there from these Portuguese selling vegetables and meat and rice across the border. At the same time as all these commercial incentives and wealth being generated, there were also cultural misunderstandings, as you can imagine, produced by differing customs and problems of language and so forth. But one of the best examples of these, I think, is the misunderstanding that took place in Canton quite early on. The Portuguese had a practice of firing off a gun, a cannon, when they arrived in a port to say, hello, we're here, we're happy to be here, hooray. The Chinese did not have this custom, and they considered it an act of war. So there was a little bit of a back and forth after that, explaining away the problem. But in addition to these cultural misunderstandings, as I said, there were strong incentives, and there were also there was also enough overlap in customs and practices surrounding trade that trade was able to flourish. And one of these areas of overlap relates to contracts and how they were drawn up. So let's look at, for a moment, at Portuguese contract law. So if you're interested in this topic, there was a huge amount written about it at the time. Handbooks and primers and treatises and all sorts of things. Much of it borrowing from Roman law, although also being influenced by canon law, so church administrative law. The reason for this is that Roman law only recognized a very small number of actionable contracts. And canon law sort of had a wider purview and also stressed the kind of consensual element that became increasingly important. So I've given you a nice little definition here from one of the most influential later treatises on contract law, De Contractibus, about contracts, commonly used by the Jesuits, printed on Jesuit presses. And it says, a contract is properly so called when, through the consent of the contracting parties and the owner of the object, or res, that's the kind of Latin word for property, to be exchanged, an obligation comes into being and is contracted. And then it goes on to kind of enumerate the different types. And thus contracts are made for purchases, sales, leases, donations, loans for deposit, commissions, other loans, leases, and other goods. And so we receive a contract in all of these works, except where it is treated as a quasi-contract. And here we're sort of getting into the weeds of pre-modern contract law. An example might be a testament. Testamentum is a type of quasi-contract because there's only one contracting party. or what they call a contractus distractus, basic and restitutions. So this is the kind of the jurisprudence side, and then of course there are lots of sort of customs and actual sort of procedures that develop. There are notaries. There's requirements for witnesses. These vary, from Portugal to England to France. They tend to have a slightly more kind of local flavor. There's also what we might call a soft law side as well. This is particularly visible in the case of Asia, because people were encountering situations that they had never encountered before. And the Jesuits, always keen to help people out, produced guidelines to help people in these sort of tricky instances. And these talk a lot about contracts, actually. I'm giving you examples here from one particular manuscript in the Torre do Tombo archive in Lisbon, mostly written by a Portuguese Jesuit called Gomes Vaz, who produced a kind of set of guidelines based on his experience acting as a go-between for Portuguese merchants. Particular issues that were problematic, it seems, if we read this manuscript, you see a bit of it on the right, relate to the trade in tin from Perak in Malaysia, sandalwood from Timor, also very valuable, but sort of issues with trade in Timor, and then cloves from the Maluku Islands. There are lots of issues with the local authorities that have to be fixed, and with local merchants. Most of the guidelines, the guiding cases, they each deal with one particular issue that they then give a sort of long form resolution to. Most of these, by modern standards, I think, emphasize the moral considerations of contracts. This is something that historians of contract law have really come to realize only come to realize in the last sort of 20 years or so, is how much of an overlap there was between theology and moral philosophy on the one hand, and contract law on the other. So we have an emphasis on, say, avoiding usury. So charging interest on unpaid goods was not on. Also on the fairness of prices. Prices are not, sort of independently set by the market, or not entirely so, but there's a question of fairness. Costs have to be taken into account. The risk of loss. You can't really, you can't forget these things. And as a result, there's an emphasis on large margins. This is something that it explicitly permits, in particular for on moral grounds, as so much could go wrong in Asia. The galleon could sink, and that would be that. So you needed large margins. They also recognize what we might call today force majeure, or sort of acts of God. And there's one particular case that discusses this in a relatively high degree of detail. So what about the Chinese side? This is particularly interesting, especially because it's probably even less understood than the European side. So that the scholarship on this is really very, very young. In fact, there are even debates about the nature of private property and contracts in pre-modern China, and the degree to which or how they were enforced. All historians do agree, however, that fraud was punishable, and if you read the Ming and the Qing codes, this is clear. But they're punishable within a sort of criminal and ritual context rather than a sort of civil law context. So it doesn't quite map as well onto the kind of the Western model. This said, you know, there are obviously mutual agreements about object price, as there are in all societies. These relate to land, goods, rents, all sorts of things. Professor Foer, David Foer, a famous anthropologist based here at CUHK, has argued that Chinese merchants contracted not as individuals but as lineages. This is something he's found for another area of China, and it's possibly also the case for the trade that we're dealing with property and businesses perhaps being held in the name of ancestors. So a kind of lineage idea of the business. There's also an important moral dimension. So this is perhaps another example of overlap. And there's also evidence from the 19th century, at least, from the new territories, in fact, here in Hong Kong, of formularies and guidelines kept in ancestral halls, kept by family lineages, that give examples of good practice, and even, you know, actually kind of, you know, contracts with spaces to write in, you know, names and the goods and prices and things like that. So, you know, pretty similar actually to what you find in the Portuguese context. There's even exemplary judgments or sort of guiding cases that were produced not by Jesuit missionaries but by scholar officials. These were particularly important in the Chinese context, of course, because the education of scholar officials didn't really involve anything sort of, you know, anything legal in the strict sense, right? To become a scholar official, you needed to study the Chinese classics, which were more of a literary sort of philosophical tradition. But then when you became a scholar official, you had to resolve disputes relating to, you know, all sorts of all sorts of issues. So you needed somewhere to turn to. And this is what we have in these collections. And so I've pulled out a couple from one of these collections from early 17th century collection that gives us a sense of what officials were expected to do. So I'll just read you an extract from this case. It says, a merchant traded along the river. Traveling along, he met the border guard. The border guard impounded the ship, deliberately harassed him, and refused to release him. Given that he is not a foreigner, and the merchandise was not smuggled, the action of the border guard cannot be tolerated. Therefore, he should be investigated and prosecuted. Okay, so here we have a sort of clear sense that the border guards are meant to leave Chinese merchants alone, but for foreign merchants are to be carefully scrutinized, and smuggling is definitely not permitted either. Here's another one about profiteering. It says, it emerged that Guangdong and Guangdong collaborated with foreigners to dominate the sale of rice for profits. They really took a lot of risks and were not afraid of death. Shenzhong and Guolong were judged to be guilty of these crimes. But Shenzhong is old and he wanted to transfer his son. So, not to be punished, but have his son punished in his place. Shenzhong should be sentenced to serve in the military. This is a sort of a kind of forced labor in the sort of as a border guard. But it is to be considered that he is in his old age, and benevolence rather than law, should also be considered. So this really gives us a sense of how judges, how sort of Chinese scholar officials acting as judges acted, their thought process, right? There was the Chinese imperial codes, there were other sorts of written texts, but they should also bring in these kind of moral considerations, so kind of benevolence, these kind of classic Confucian virtues as well. Finally, as a sort of topic maybe you haven't thought about in a historical context before, the tax environment. This was also as important then as it is now, because every port and state in Asia levied taxes on merchants. It was a great source of revenue after all. In Macau, there was a 10% duty on the Japan trade, and then there was another 20% in Canton, which was the typical 20% tax levied on foreign merchandise. In Macau, duties were assessed when a ship arrived. The procurador went on board with his sort of guards, his henchmen. As the merchants complain, they assess the value, and they allow 90% then to go to the factories, keeping 10%. Whether that really was 10% in weight, the merchants usually disagreed. They often complained that the procurador had overly heavy weights, and so was taking more than his 10% and then selling the excess for profits. This resulted in a lot of smuggling, of course, and the Chinese were also keen to clamp down on this. So they further narrowed the parameters for trade. They said that ships sailing from Macau to Canton had to be accompanied, and they had to go on a particular route that was kind of a narrow route between the islands, the kind of inner route as opposed to the main route straight up the Pearl River. This allowed them to keep a sort of closer level of control, and this continues with the Qing after 1644, when the Ming Maritime Trade Commission is replaced by the Qing Maritime Customs Authority with a Manchu, so a sort of Qing ethnically member of the new ruling ethnic group being in charge. All right, so that's enough about that. Let's have a little look at family law, at something a little bit different. And for this, I want to just bring us back to Rome for a minute, back to our bit of virtual research travel, and to take you down a little side street beside the Jesuit church. Along this little street, it's a very pretty little street. And on the right, you'll find this library. This is the Biblioteca Casanatense, founded in the 18th century by a cardinal, and having one of the finest collections of European manuscripts relating to China in all of Rome. And it's also one of the most beautiful libraries as well. It's really a pleasure to work in, as you can see from this picture of it. But on to the question of family law in particular, this particular library, as well as being beautiful, is useful because it contains a unique bilingual Latin-Chinese manuscript treatise on a particular sort of thorny question of cross-border law, that of marriage. This was written by a French missionary called Charles Maigret, and it was entitled, in translation, a dissertation on Chinese marriage. Like all treatises, it came out of a very particular context that we have to, as historians, understand. It was written during the Chinese rights controversy, debates about the degree to which Chinese converts to Christianity could keep Chinese customs. What was a sort of civil, they called them civil customs versus religious customs. So what was a kind of a deal breaker from the perspective of Christianity? Could you worship the one true God and also engage in ancestor worship? Was that a problem? And I guess sort of second or third on the list of issues that were debated was that of marriage. This had been a problem for a while already. In particular, the validity of pre-existing marriages of Chinese converts. So you get married and then you convert to Christianity. Is the marriage still valid? And then what if you have a Chinese marriage ceremony after you've converted to Christianity? Is that the same as having a Christian marriage? And this, to answer questions like this, you obviously have to have quite a deep understanding both of Christian marriage and of Chinese marriage, which is set out in the several hundred folios of this manuscript, with the main text, as you can see on the right, being written in Latin, and then with footnotes in Chinese. So the sources clearly cited, these being, for the most part, classical Chinese sources, as well as contemporary legal sources. So we have things like the Chinese Book of Rituals, so Confucian Classic, we have the Ming Code, we have Song and later encyclopedias. This is a really pretty formidable work of erudition that we are dealing with. And it takes all these sources as well as canon law, and it brings them together to create a comparative framework for understanding marriage within this, we might say, cross-border or maybe cross-confessional context, with the aim of understanding the reality and then harmonizing it, and creating a workable framework for the Christian sacrament of marriage when administered to Chinese converts, be it in Macau or in China. So what were some of the issues that they bumped up against? Well, the first one is obviously the fact that in pre-modern China, concubines were quite common. So there was a man could have a wife, and then he could also have concubines, jie, right? This is something actually that isn't entirely alien to the Western tradition. The Romans had an institution called concubinatus, so concubinage, I suppose. But this obviously didn't survive the advent of Christianity, which saw marriage as a union of one man and one woman. Maigret explains a little bit more detail about Chinese concubines. He says there are two types, in fact. There are secondary wives. These are drawn generally from this sort of not the upper class, but the sort of the non-degraded classes of society. So people in honorable professions as opposed to sullied professions, like musicians, actors, you know, those sort of people you can't really trust. It was the same in pre-modern Europe. They didn't have a very high opinion of actors and musicians. But anyway, the secondary wives were the Yangmin, so honorable people. They could not be sold, and their children were considered legitimate. So they really are secondary wives to all intents and purposes. And then there's a sort of a lower category of the slave concubine. So the Mutia. These were women whose probably their male relatives had been sentenced to some capital crime, normally some sort of crime against the state, and then their womenfolk were sold into slavery, becoming these slave concubines, and they could, it seems, be sold in some contexts. The reality, so this is the kind of the theory. If we read the kind of social historical scholarship on this, we see that actually both categories seem to have been alienable. It seems, especially in urban contexts, there was a sort of a brisk market in concubines, and we even have an example from this period. So we have a description from 1647 when a Ming official, right, the Ming are on the way out, and the Qing are coming in. A sort of former Ming official is being held by some Qing soldiers, and he sells a concubine to pay his ransom, to buy himself out. And we have other examples like this as well. So that's the issue of concubines. Then there's also the question of the consent theory of marriage as something that's at the core of Christian marriage, although its roots can be traced back as far as the classical jurists like Ulpian, who says nuptias non concubitus et consensus facit, so consent, not physical intercourse, constitutes a marriage. This is then built upon in the Third Lateran Council, and then is kind of written into theology and canon law, mixed with the Aristotelian idea of one of the four Aristotelian types of causality, with consent being the efficient cause of matrimony. This is not the case in pre-modern China at all. Marriage was the decision of the parents or other older relatives, and it's a decision normally made in the interest of preserving the patriline because of strict patrilineal inheritance laws. This is not to say, of course, that all women had free choice to marry in pre-modern Europe, especially in a sort of aristocratic or royal context. But the theory was anyway that consent was required. Not so in China. So Maigret tells us, citing various parts of the Ming and Qing codes, he says, it is to be observed in the first instance that the parents of the children, and in particular the daughters, are the ones who ultimately make the decision. However, it is not only the parents who have this power. If they are unable to do so, those in the household who are superior to them can choose. So this is nothing like the consent theory of marriage at all. And this is the document here, as you can see. right? It says, exactly. Parentes decernere. The parents decide. To add one final issue, Maigret mentions but dismisses issues surrounding the differing custom of the bride price versus dowry in China and the Western context. So dowries, right, are when the bride's family provides money to the husband's family, and the other way around is called a bride price. It's a word you may be less familiar with, but it's when the husband's family pays a dowry, essentially. The custom of the bride price is actually something that does exist in pre-modern Europe. It's common in Germanic law. Sometimes called the Rittermun, and it's different from the dos dotis, the dowry. But anyway, so this was a difference. Maigret recognizes it, but because a dowry wasn't a prerequisite for marriage, it's not a serious problem. So Maigret describes it, but he says we can pass over this problem. Although he does note it is an area of striking difference. So he says, it should be noted that an area where Chinese customs most differ from ours is in terms of the husband and his parents providing money. It says pecunia, money, rather than the bride and her parents providing a dowry, dotem, right, dowry. And the bride, if we are speaking properly, is thus sold, a term people are not afraid to use. Although he says it's not really selling, it's more giving an honorarium. So it's like if you give a talk, I suppose, if you're an academic. That's what he compares it to. And then he cites in the footnotes passages from Jushi, the Book of Rights, and other classical Chinese texts. And this is the original manuscript here. All right, on to the final section. So, slavery and cross-border crime, what you've all been waiting for. There was quite a bit of it, and both the Chinese and the Portuguese authorities were very aware of it and tried to limit it. The Portuguese, in fact, normally being particularly keen to make sure that any Chinese laws weren't broken, because they wanted to maintain trade and good relations with the Chinese authorities. Evidence for this sort of process of negotiation and cooperation is clear if we read the correspondence, the letters that survive between the Mandarins and the Portuguese. We have some sort of 18th and 19th century examples in this archive on the right. This is the sort of Portuguese Imperial Archive in Lisbon. And these letters talk about all sorts of things, smuggling, assaults by Chinese on Portuguese in Macau, on African slaves of Portuguese on Chinese merchants in Canton, all sorts of things. There's also illegal border crossing. And then there are various discussions about permits and other things, not only for Portuguese merchants, but also once we get into the 18th century, the procurador, the officials in Macau are negotiating on behalf of Dutch, English, and Danish merchants as well, who are using Macau as a sort of trading hub. So let's take a look at some of these very, very interesting documents. We have the letters from the Chinese side in this collection called the Chapas Cínicas. So here's an interesting one. This is dated 1746. It's from the assistant magistrate in Shangshan County, right now, now Zhongshan, named after Sun Yat-sen, and it's addressed to the Procurador of Macau. And it says that the Chinese people smuggling sulfur, presumably for making gunpowder. They were caught, they admitted to it, and they further noted that their intention had been to sell the sulfur to a foreign ship off the coast of Macau. The Chinese authorities are very unhappy about this, and they ask the Portuguese Procurador if he has any knowledge of this foreign ship off the coast of Macau, and whether he can offer the Chinese some assistance in identifying it. So that's our first one. This is our second one. This is a little bit later. This is 1798 by another assistant to the magistrate in Shangshan to the Procurador, and this is about a runaway slave and illegal border crossing. So it talks about He Guinu, so a black foreign slave who's caught in a small village in Shangshan. They give a description of his appearance, what he's carrying, and they want to return him to his master. This is, of course, because within the Portuguese context, slaves are considered property. They're under dominium, that kind of ownership, and this was the custom even in the age of Ricci for returning slaves to their masters. Okay, this is probably my favorite. This is from Wei, another assistant of the magistrate in Shangshan to the Procurador. It complains that an American ship, docked in Taipa, so to the southern side of Macau, went up to Taiching, so went up the Xizang River, and sold illegally 400 crocodile skins, Hailong Pi, so literally sea dragon skin, a sea dragon being a crocodile. This is forbidden, they say, not allowed at all. The ship must immediately return home and never do this again. Huiguo, right? Head back to their own country. Indeed, special permission, it notes, was required to import crocodile skins, and we have some evidence from slightly earlier in 1792, and again from that same year of 1798, of people applying for these permissions to import crocodile skins. This is something I want to look into a little bit more. I had no idea about this illegal crocodile skin trade. I'm sure they weren't, making cowboy boots. So I'd be very interested to know actually what they were doing with these. Yeah, I guess here's another one about crocodile skins. This is arguing that someone who had purchased some illegal ones was not to be punished. Instead, the slave who had stolen them and sold them in China should be punished. And this is yet another example of the degree to which slavery appears in this official correspondence between the Chinese and the Portuguese authorities. And this is something that those of you who attended my earlier lecture will, of course, be very, very familiar with. This is, I guess, one small corner of a larger sort of world historical phenomenon, right? Remember that in the pre-modern world, treating people as chattels or movable property, if you like, was very, very common. There's slavery in the Islamic world and the Christian world. People are alienable in mainstream China, in India, similarly, Southeast Asia. There are various forms of slavery or slavery adjacent statuses. And when the Portuguese expand their trading routes across the early modern world, they to some extent tie together these markets into a world market, just as they do with the other commodities that they trade in. It shouldn't really be thought of as sort of separate from a kind of economic perspective. So this is the world of the Spanish and Portuguese, right? And these are the markets they tied together, both in silk and ceramics and in slaves. This is a slave market. This is a slave market in India. You see on the sort of front left a slave, maybe South Asian, maybe African. It's unclear, being sold. And probably similar things were visible in Macau during this period. These slaves were not, however, all Africans. In fact, far from it. There were Chinese purchased from Chinese merchants, sort of people traffickers, smugglers in Guangdong. There were Indian and Southeast Asian slaves transported there. There were Japanese slaves brought in from Nagasaki. And there were also Black African slaves brought from East Africa. The reason this is in the cross-border crime part of the talk is that there was a Chinese prohibition against Chinese people being sold to any foreigners, not only the Portuguese, and being transported beyond China. This was in addition to the prohibition of keeping Japanese slaves who I mentioned were considered dangerous, were associated with piracy. All other types of slavery were fine, but Chinese people and Japanese were not fine. The Portuguese, the Portuguese authorities, I should say, eager to keep the Chinese authorities happy, also promulgated an edict against buying Chinese children. Jesuit theorists also weighed in, writing treatises that touched on questions of the legitimacy of the Chinese custom of selling servants and slaves, of penal slavery, of selling children during famine, which happened a lot in China. So there was a lot of kind of legal back and forth about this. This doesn't, however, seem to have overly affected the trade, which simply went underground, with Chinese people traffickers regularly selling women and children to the Portuguese in Macau, despite all these efforts to reduce it. And in fact, we have from a casebook from a prefectural judge a prosecution for people trafficking. It's a rather interesting case because it's sort of the authorities intervene sort of before the sale has actually taken place. So it describes Churame, who attempts to kidnap the daughter of another Chinese man, Huang, to sell in Macau. He's caught before he can actually sell her in Macau, and so his punishment is reduced from death to a fixed term of penal servitude, so sort of hard labor, far away from his home province. The legal reasoning behind this comes from the Ming Code that forbids kidnapping and human trafficking, especially of decent people. And then there's also a later substatute that's mentioned in the casebook regarding selling people beyond the borders of the empire. Okay, sort of separating people from their homeland. That's the sort of the legal reasoning that we see. There's also something very, very interesting that develops in this period, which is something of a workaround And the Jesuits, perhaps not to their credit, are heavily involved in this. They see that because holding Chinese slaves was illegal, that if you sort of hired people, if you produce legal documents that said their period of servitude was limited to, say, 20 years, it could kind of get around the ban on slavery. So they came up with this system of ownership, so dominion, in the sort of Roman slave law sense, but limited to 20 years. This, therefore, technically was neither human trafficking nor slavery from either the Chinese or the Western perspective. And it also mirrored Chinese customs that involved sort of long-term contracts for household labor, for sort of drudges, young girls working in households. These are the famous mui cai that we get in, debated in 20th century Hong Kong. So they find this kind of very interesting way to kind of avoid the issue and kind of harmonize the Western custom with the Chinese custom to some extent as well. All right, so that is all I have time for, I think. I'll just sort of give you a quick rundown of some of my main thoughts, and then we can maybe move on to questions. So first of all, I think when we're dealing with this question of early cross-border law, it's really important to look at both the print and the manuscript evidence in both Portuguese and Chinese. If we do this, I think a couple of things become clear. First is the really profound degree of legal pluralism that we see in Macau, even as it remained part of Ming-Qing China. This sort of process of negotiation, harmonization, this ongoing world of this ongoing kind of pluralistic context allowed cross-border trade to flourish, and for contracts to be exchanged, and in some instances enforced, although sometimes this was difficult. Missionaries, we saw, studied Chinese marriage law while in Macau, and they used these sort of, I guess, missionary anthropological studies to then understand Chinese marriage law and attempt to harmonize it with the Christian sacrament. And then finally, cross-border crime was a constant concern for both the Chinese and Portuguese authorities: smuggling, people trafficking, illegal crocodile skins, the whole lot. Such things are by no means new. Similarly, issues surrounding negotiation and harmonization are apparent even in the 16th century, as are various sorts of conflicts, which in these sort of cross-border contexts, I think, inevitably arise. Thank you very much for your time.
Thank you very much, Stuart. That was excellent. Thank you. I really enjoyed that sort of coverage of, as you say, something that not often has been, well, I don't think looked at in that particular way. It was very good as well. Thank you for mentioning Professor David Four, who of course gave the first ever seminar in the whole series. And of course your sort of talk about business organizations based upon plans and ancestral trusts, of course, was something I think that was covered in the second year. So maybe we need to revisit some of those things. You've sort of, yeah, I think we need to go back and think about some of those things as well. I've already had a number of questions. Please feel free to, we still have about 10 minutes for questions, so please feel free to send them in, but I've had a number already. Shmuel Yerushalmi has asked, do you think that the interaction in this period led to any changes in the Chinese legal system at all?
So I can't think of any examples off the top of my head. We have to remember that Macau is very small, right? The population is about 6,000. Of Portuguese, it's about 1,000. I think we should also understand that what's happening in Macau is it's not truly the first time that this happens in Chinese history. There's ongoing trade right along the southern coast with Southeast Asian merchants, Muslim merchants. So I think as a historian, I would always want to place it within that larger context, and therefore any results it might have would be part of a longer process of kind of legal exchange, let's say, and borrowing. I think the truth is that we actually don't. Chinese legal history is still very heavily reliant on the dynastic codes, which certainly don't show foreign evidence. It's the case books and those kind of guiding cases that we really need to look at. And we have a colleague in Hong Kong who started this process, but I think it'll be a while before we could give actually a good answer to that question. So it's an excellent question.
Thank you. We've also, as you would have guessed, had some questions about slavery as well. You mentioned a couple of cases where you said that the slaves were actually, there was a problem because the slaves, well, they've been selling crocodile skins at one point or whatever, which sounds fascinating, as you said. Do you think this was a sort of an initiative on behalf of the slaves, or do you think that they were being used by their masters to actually carry out these illicit activities?
Yes, so I think there's a reasonable possibility that that's the case. We don't have any evidence in this instance, but we do have complaints from other parts of the Portuguese Empire that people would, send their slaves to beat up a rival or to kind of create a disturbance, right? So the kind of use of slaves to do the master's bidding in a kind of very broad sense is very clearly evidenced. At the same time, I would say that we have to be a little bit careful about the Chinese terminology, because what we have developing in the pre-modern world is this Chinese tendency to kind of use black slave or black foreign slave as a kind of catch-all term for anyone with very dark skin who is kind of associated with foreign trade. So actually the status of these people, we should look into exactly what they mean by that. Do they know that they're a slave? Is it an escaped slave? Western slavery has manumission. Is it a free slave? The libertus? We need to. So it's a very historian's answer, isn't it? We need more research is required. You have to dig into these categories a little bit.
Well, yeah, it'd be interesting to find if there were any reports of this sort of thing going on. And then also on that, the idea of the Jesuits getting around that restriction on slavery in China, using those 20-year contracts, that sort of indentured servitude sort of idea. From Eugene Tiao in University of Melbourne has asked, can those 20-year periods, could they be consecutive? Could someone be, subject to this 20-year period, and then have you seen any evidence of this?
I haven't. What I do have evidence of is people staying on in the household as kind of free servants. And I think that's probably what happened. It was actually a big issue for freed slaves is what they did after freedom, because their entire lives have been tied to this particular household, and their economic opportunities, unless they have been trained in some particular trade, that sort of impose certain limitations. So we do have evidence of freed slaves remaining in the household, whether to what extent their daily lives changed, I mean, the evidence doesn't quite allow us to say. They certainly couldn't be sold. No Jesuit would, sign off on a contract, be a witness to a contract in those circumstances. So maybe that was an improvement. But the tasks they were undertaking were probably quite similar. So that's what I'd say for that.
Thank you. We've also got a question on piracy. So the Chinese were obviously very concerned about piracy, but we're also getting the question that the Portuguese, of course, were very concerned about piracy as well, particularly around the area of Hong Kong, which they referred to as the Islands of Thieves at one point because of the problems. Yeah. So the question is, did the Portuguese and the Chinese work together against pirates? Or
so they did. Initially, the Chinese consider the Portuguese just to be another lot of, I call them trader raiders, because in this period, business can be done in a variety of ways. It's just business has to get done. So the Portuguese, they do a little bit of piracy, they do a little bit of trade, and then they team up with the local Chinese authorities, and they set themselves up as kind of a bulwark against the pirates. So they say, if you give us Macau, we can stay there and we can keep the peace, and you won't have to spend any money on patrols, because having constant patrols, right, is very expensive. So if the Portuguese are there going back and forth, they can sort of play that role, and that was generally one of the justifications used by local authorities when writing to the central authorities for the presence of the Portuguese. They're useful. And then, of course, when we get to the Ming-Qing transition, the Portuguese are useful because they have gunsmiths as well. And both the Ming and the Qing make use of, Portuguese sort of gunpowder technology of various sorts.
Great, thank you very much. This may be a little bit out of the period, but it sort of follows on from what you've just been talking about there. At what point did Macau's governance become completely autonomous from the Chinese state? And what were the circumstances around that? And did the British taking of Hong Kong affect the state of law in Macau?
So, I mean, it starts before before the 1840s. I mean, it really starts around about 1800. And its association, I mean, with the general kind of shift in the balance of power, geopolitically. This happens across the Portuguese Empire. In Goa, it's the same. In Goa, they expand, actually. They have a kind of new territories in Portuguese. They call them the new conquest, novas conquistas. And it's yes, I mean, it predates Hong Kong, but it's part of that same kind of process that we see the Great Divergence, plays out here as well.
Excellent, thank you very much. We have got, I think, probably a minute to ask one more maybe question. Thank you for pointing to the different places where you found your sources. Regarding the testaments of Shao and Cao and the Ming Shui Zai Shai documents, where are they found? How many of these documents exist? Is it possible to draw general conclusions, for example, about the functioning of contracts from these sources, or are these rather individual cases? So quite a lot in there for a minute.
Yes, absolutely. So these cases are actually printed, and they're used as, they're used as kind of either textbooks or kind of primers or something for young magistrates, because, as I said, they have training in pure classics and not law, so they have to do those a couple of years. There's PCLL or whatever equivalent, right, to kind of actually get to know how the whole thing works. It is, of course, fragmentary, but it's on par with the evidence we have for the Western context as well. And of course, historians never have all the evidence you want, right? So you have to start somewhere. And these, there are hundreds of cases in these collections. And I'm trying to sort of collect them under different headings and sort of get the patterns of, sort of see the historical patterns by looking at multiple cases at once.
Excellent. We look forward to your casebook when you get that together. That will be a very interesting book. So thank you very much for a fascinating talk. As always, Stuart, it was a great talk on a really interesting subject again. I am asked just to publicize some upcoming events. So if my colleague Jay, if she could share with us, yes, we have, I think, 4 events to tell you about. The first is the next, and of course, the last in this year's series of Greater China Legal History Seminar Series. The last, but of course not the least, because this is the seminar delivered by our Dean, Professor Lutz Christian Wolff, and it's on the development of China's inbound investment law. So that's on the 18th of March, again, a Friday lunchtime. So please join us for the last in this series of the Greater China Legal History Seminars. And then we have the next in our property law seminar series, which will be on the 16th of February. So I think that's next Wednesday evening between 6 and 7 p.m. And we have our colleagues, Professor Calvin Lowe used to be at City University, but is now back at the NUS, Professor Wan Wai Yi and Mr. Alwin Chan, who will be talking about private takings of land for urban redevelopment, a tale of 2 cities, Singapore and Hong Kong being compared then. So that's next Wednesday evening. And then we have the latest in our teaching and learning seminars, which is my colleague, Professor Queenie Lai, who will be talking next Thursday evening on the 17th of February about how to encourage student participation in online learning, something we all need to get to grips with today because of online teaching. And then the final event we'd like to tell you about is, yes, I think Jay's just going to go to it now. Oh, there we go. It's a public lecture on equality by Mr. Justice Bakari. This is obviously one of Justice Bakari's talks. They're always very interesting, but this one is in memory of the late Mr. Vincent Connor, who was one of our advisory board, who very sadly died at the end of last year. So this is a memorial lecture given by Mr. Justice Bakari, 22nd of February. Please join us for that. Again, it will be online and you can sign up for it. Thank you very much. So then it remains for me to thank all of you for joining us today, to thank all of you for giving up your lunchtime for this fascinating talk and joining us for the latest in the Greater China Legal History Seminar Series, to thank my colleagues, particularly Jay, who's been organising everything and supporting us all, and without whom everything would go terribly wrong, I'm sure. So thank you very much, Jay and the team, for supporting us for that. And again, to thank Stuart for a fascinating talk again. So thank you very much, Stuart. And we look forward to your next talk in the seminar series.
Thank you very much for the invitation.
Thank you. Apart from that, just thank you very much and goodbye. We are CUHK Law. Bye-bye.